Good morning, everybody. Hopefully everybody can hear me okay. My name is Grant McKellar, and I'm the Director of the Crime Victim Assistance Program. I'd like to thank everybody for joining us today. Hopefully I can provide some insight on this new benefit that we've just added in the last couple of months. We do have an hour and a half today booked, so there should be plenty of time to answer any questions. I'm going to open up for questions over the phone at the end. But by all means, if you have particular questions as I'm going through, if you could type them in for the people who are viewing the presentation, and I'll try to answer as many as I can throughout the presentation. So hopefully, technologically, everything is working okay. If not, Steve will try to do his best to try to fix things on the fly. But unless there's any massive things going on out there with technology, I'm going to get started. So what we're doing today is introducing a new benefit that we added, an additional counseling benefit for counseling for assistance for legal proceedings, or we're calling it within the program that it's counseling for court support. Technically within our regulations it's actually for legal proceedings, but court support just makes it a little bit easier for us. So as a bit of a background with Crime Victim Assistance Program, and hopefully most of you are aware, is when we determine eligibility for benefits, every single claim that we accept, we award counseling to. Pretty much it's then the determination of the claimant themselves on whether they choose to access it or whether they choose to access all of the counseling that we can award them. But what we do is when we're making our decisions and accepting a claim is we assume that there is some level of psychological trauma. I'm just going to pause for a second. We're getting a little bit of feedback until Steve mutes. All right, we should be good. Is we assume there is some level of psychological trauma for everybody who's been the victim of violent crime, so we certainly award counseling to everyone. The counseling benefits that we award are set within the regulations as far as the number of counseling sessions that we can provide. So that is set within the regulation. We don't really have any leeway with that because our regulation is the law, so we can't exceed the number of sessions that are set within the regulation. The numbers I'm giving all relate to adult victims. When the applicant, whether they're a victim or immediate family member, are a minor at the time of the offense, these hard caps don't specifically apply, so we can't exceed those if the circumstances warrant it. But for adults, victims are entitled to a maximum of 48 sessions. Immediate family members, and immediate family members for us is certainly a defined group of people. So that is for spouses, children, parents, and siblings of the victim, and so that's up to 36 counseling sessions. Yeah. And for our eligible witnesses, it's a maximum of up to 12 counseling sessions. So we award benefits, like I said, on the initial application for counseling. The vast majority of our clients do not take all of the counseling that's available to them, but there certainly is a much smaller group who actually use all the counseling that is available to them and likely could use more. So as a bit of a background, so for us, our claims never essentially close. They certainly do physically close, but they can be reopened at any point in time. So counseling is available to that person basically for their lifetime, so long as that counseling is particularly needed as a result of the offense that gave rise to that claim. So our clients can access some of the counseling now, and they can come back at any point in the future if there has been some triggering events that require them to reinitiate with counseling, or if it's just a point in their life they're now actually prepared to take the counseling. Again, so long as it's in relation to the events of our claim. Our counseling is very particular. It is relevant to that particular offense as far as why we're providing counseling. In particular, when we're looking at this new benefit, we certainly understand that legal processes can take time, often years after the time of the offense. and we've certainly noticed that there are lots of our clients who have used up almost all of their counseling, if not all of their counseling, by the time that legal proceedings, especially particularly trials or parole hearings, much further down the road, have occurred. And because we are hard capped at the number of counseling sessions, we weren't permitted to do anything else. So we certainly looked at legal proceedings being a triggering event in almost all circumstances as far as counseling. And we didn't want people holding back or holding their counseling for that purpose as well, because it certainly delays anybody's healing process. I have a couple of people who are saying that their PowerPoint went off. I'm hoping that's just a local issue, not global. I'm going to assume that I'm assuming it's local because I haven't received a whole barrage of people saying that it's off. For the people who are following along just by the presentations and not online, I am now on slide 4, which the title is Counseling for Legal Proceedings. So in recognition of what the additional trauma from legal proceedings can cause, we added a new benefit. Now, I'll say that again, this is a new benefit, it doesn't replace any of the counseling that we've normally provided. This is a new additional group of counseling benefits. All right. And I'm just sorry, just give me a second. I'm just reading some of the questions that are coming in to see if I can answer them as I'm going on. One of the questions that I've received is if the victim is approved for benefits for childhood sexual assault as an adult, would they be considered yes for more than counseling session 48? Then that answer is yes, it matters for us. The age of the person at the time of the offense, not the time that they're applying. So as long as they were a child at the time of the offense, in the 48 counseling session is not a hard cap. And are the lifetime counseling over and above what their employee benefits would cover? Yes, they are. So the new benefit we provided is for the counseling for legal proceedings is, for the most part, it's about half the block of what we can provide to adult victims. So victims can receive up to another 24, immediate family members up to another 18, and witnesses we put it at 12, which is basically doubling what we because we certainly know that witnesses, for our eligible witnesses, they will be required in court as well. So it made more sense to give them additional 12 rather than 6. Now, these sessions that we can provide are fixed, and they're fixed for all the approved legal proceedings related to that person's claim. So it's not 24 for each different legal proceeding. It's 24 total for the claim. So that we want to make sure that people are using them correctly, which is part of today's presentation, because we don't want people using all 24 based on the preliminary, and then by the time there's a parole hearing 6 years later, there's none of those left. So that is 24 total, not just for each legal proceeding. One question I got here is, does this benefit have to be applied in the first year as other applications? Certainly not, and actually none of our benefits have to be applied within that first year. People have 1 year to actually submit their application, but not to access their benefits. We have a 1-year time limitation as far as submitting an application, but not in actually using counseling benefits. We do have lots of claimants who are coming back for counseling years and years after the fact because of triggering events. So that limitation applies to the application, and the limitation doesn't apply to any sexual offenses whatsoever. The time limit does not apply on those cases. And we'll receive a hard copy of these figures or this PowerPoint. That should have been sent out to you. So take a look at the information that was sent out. There should be a PDF version of this PowerPoint as well. Steve, I've got a question here that I can't answer. Can we print off this? Because it's not allowing me to do so.
Yeah.
Yeah. PDF should be printable, so I don't know what's going on there. So legal proceedings. The legal proceedings that we cover are specific types of legal proceedings. They are preliminary inquiry, trial, sentencing or review of sentencing, appeals, Coroner's investigation or inquest, that is new, that we've added that into what our definition of legal proceedings have been in the past. And hearings under the review board, so that's basically for those who have been found not criminally responsible. So it's these legal proceedings that we actually can provide this additional this benefit for. The one thing that we do is the way the regulation is worded, it allows us, as far as CVAP staff, to determine on whether any of these processes have started, because these benefits, the legal proceeding benefits, are time limited, which I'll get into as far as when people can actually use them. So they can start using them from when the legal proceedings have started up into a date, which I'll talk about in a minute. So it has to be these particular legal proceedings as far as when we're actually providing the benefits, but it's our staff who can determine on whether they actually have started, whether it's actually, for example, if we have a murder trial, we know likely there's going to be something started, so we can actually accept that we can do those even though prior to preliminary inquiry to start, because we know one of these proceedings isn't going to happen. One question I have here, children who are victims have an unlimited number of counseling sessions, or is it capped? I would not say it's unlimited. I mean, the intent of our program is not to provide an unlimited lifetime amount of counseling benefits. We are providing counseling to try to have people recover to the best of their ability, and to then for children to meet when we're dealing with those triggering events, and we're looking at that person, there has to be progress in that counseling as well. The intent of our program is not to provide ongoing counseling for the rest of somebody's life. So we will be asking for progress reports and actually indicating there is progress being made, and looking at it for triggering events, but not to provide ongoing monthly counseling for someone forever. For those following along, I'm now on slide number 6, which is legal proceedings. So the legal proceedings, the counseling sessions are available from the time that they start until 18 months after their conclusion. Because these benefits are specific to assist people through the legal processes, it has to be particular that it's actually supporting them through the legal processes, so it doesn't go on forever. But 18 months after those processes are completed is the date within the regulations that we can no longer award these sessions or pay for these sessions. However, what we're saying here is, one, again, I've already mentioned that we can determine when they've started. Particularly these sessions, one, they are not available for anything in relating to civil claims, so that includes family court, anybody who's deciding to sue or going through small claims court. These counseling sessions are only available for the criminal proceedings, nothing to do with civil. And, oh, missed one. That perhaps I think it's on another slide, but I'll talk about it now, is, again, people have 18, when we're talking about the 18 months after their conclusion, that date can start and stop and restart again. So, for example, if someone has now gone through sentencing and they can access these counseling benefits for 18 months, and then 6 years later there is a parole hearing, then those proceedings have started again, and we can now, if there is these counseling sessions are still available to them, then they can start accessing these sessions again. And then the 18 months from the time it had started, the clock starts turning, basically starts over again, and they have 18 months until the conclusion of the parole hearing. So these sessions can be used periodically, over many, many years, depending on how often the legal proceedings as a result of the offense from our claim still continue to appear for our victims or our immediate family members. So one of the questions is, I've had plenty of times before, is when will these benefits will be awarded? For the most part, for the claims that we receive, we are awarding them to everybody when they come through the door, so long as we can see that there likely could be legal proceedings. So we're not putting into decisions where people have said that they haven't reported the offenses to the police, or they don't intend to, because we don't expect there will be legal proceedings there. We are putting into anyone that we think that there may be legal proceedings. So that wording is in there that basically tells our claimants that this benefit exists. However, the responsibility is on the claimant to let us know that the legal proceedings have started. Because of the volume of applications that we get, there's no way for the staff here to monitor that. So if our claimants need to use this benefit or choose to use this benefit, then they need to call us. we can then do our checks to make sure that the proper legal proceedings have occurred so we can actually pay the benefit. But currently, I would say, I mean, we're receiving about 4,500 applications a year, and we probably have about 5,000 applications that are active at any given time. So there's just no way for my staff to continue to monitor on the client's behalf. They will have to notify us, or if the counselors are aware that the counseling they're providing is in relation to the fact that there is a court process ongoing, is to have that contact with the program. Question I have is, if the adult has 24 sessions and they use 20 after the trial, does that mean they only have 4 left for parole? Yes, that is how it works. It's 24 for the lifetime of the file in relation to that claim. So yes, we want to make sure that people are actually using them appropriately. And again, this is in addition to the regular counseling that person has available to them as well. So they still have their 48 counseling sessions that are available for everything that is not court related as well. Or if they run out, that they can use their regular counseling sessions for that purpose as well. I have a question as well about how the program distinguishes between court support counseling and the regular sessions. I will get to that in a future slide, so just bear with me on that. Again, once we're notified that people want to access this benefit or the sessions are for court-related proceedings, we can then review and then make a decision about the payment of the benefits. So we do have access to Justin, which is the court system, which can tell us that where somebody is at within the court proceedings. If it is something that we don't have access to anything in relation to the parole board, so we will require information from the claimant particularly about that and what's going on, because that's something we can't access on our own. And I've got a question: does this benefit include when the Crown decides not to proceed? If the Crown is not proceeding, then there is no legal proceedings, so this benefit is not available. This benefit is specific to help people through legal proceedings. If there is no legal proceedings, then we can't provide anything. And I also have a question about fees. I certainly understand about the fee rate and what we're doing. That our fee rate is set within regulation, so that was not part of this amendment. I certainly have heard lots about those fees, and it is something that we are fully aware of and looking to see what we can do something about. But it was not part of this amendment as far as increasing the counseling fees at this point in time. And again, a follow-up question to whether Crown decides not to proceed. Yeah, even if there's a police report, again, this is for not assistance through the police or the investigation process. This is an additional benefit for assistance through the court process. So time limitations, as I said, it is for 18 months from the time that those legal proceedings expire. But again, that can expire and restart again, depending on what is actually happening in the legal proceedings. The vast majority of our claims, the vast majority of actually all claims that are reported to the police, don't actually go through court, and the vast majority of them are not something that is long-term court processes. Certainly, we do have some that go on for years. But for the majority of our claims, it's in court and it's out of court, and it's usually not. We're not usually dealing with a lot of our files and things like parole hearings or review board hearings, that kind of thing. I have a question about the qualifications required for counselor for this type of support. The qualifications for the counselor are the same as qualifications for the counselor for any other counseling that we pay for. Counselors, when we pay the counselors directly, they do have to register with us. By regulation, we can't pay counselors unless they actually have appropriate liability insurance, that they pass a criminal record check, and that they fit within one of the 5 categories of counseling support within Schedule 2 of our regulations. The vast majority of our counselors are master's level counselors, and we also have registered social workers and psychologists as well. We have very few counselors that we've approved that actually fit somewhere below the RCC master's level counselors. But the type of counselors that can provide this are the same as with every other counseling benefit that we provide. And the next question is, with the exception of sexual assault cases, does the applicant still need to apply within 1 year of the crime? Yes, they do. The one-year time limitation certainly applies. The legislation does allow us to extend that time limit depending on whether it's reasonable that person could not have submitted their application in time. So if somebody is saying that the reason why they didn't apply is because they didn't realize the impacts of court on them, that could certainly be the reasons why they're applying out of time. But it's the responsibility of the claimant to let us know why they have not applied within time limitations. But if it's a non-sex offense and it has applied after the time limit, we are required by our regulation to consider that. We do need an explanation for 100% of the time from the claimant as far as why they didn't apply in time, and then if their reason is sufficient, then we can accept it outside of that time limit. I've already given this example as far as that they can stop and restart again. So I'm now on billing for this benefit. So this is particularly for the counselors out there as far as how we're billing for this benefit. Is one, we want to ensure that the claimant has access to the maximum number of counseling benefits that are available to them. What we do need the counselors to do is when they are aware that they are providing that the counseling session is in relation to what is going on with the legal proceedings, to indicate that that is on their invoice that is either to put court support or legal proceedings or something that flags it for us, because otherwise we are not going to know. Really, administratively, it's because we provide probably last year about $2.3 million in counseling, usually one counseling session at a time. We don't have the ability to actually continue to monitor or phone every single counselor to make sure what it was for. So we do need the counselors as best we can to flag what these sessions were particularly for. And if they were to assist that person because of what is happening in court, then we are requesting that the counselor flag that on the invoice so we can apply it to the right benefit category. Without this indication on the invoice, we'll assume that it is part of regular counseling, because my staff, especially if when we're talking about paying for counseling a year and a half post offense, we're not going in to check to see if there's court proceedings ongoing, right? It's because we put that onus on the person letting us know that this is in relation to counseling, is that will apply to the regular counseling benefit. Couple of questions that I figured people would ask. Before I do, I've got a question on here. Does CVAP inform clients that they approve for counseling, the difference in the counseling structure, i.e. seeing a counselor does not registered clinical counselor? Not exactly sure what that means. When we approve counseling, we advise in our decisions that the person has counseling and that they should be speaking to their counselor about what we provide, how much we provide, to determine that that counselor is willing to accept. We do not direct our clients to any particular counselor. We certainly advise them if they see someone that they are comfortable with, and that counselor can contact us for registration. It's not just limited to the people who are currently registered, because there are lots of counselors who may choose to be registered after the fact. So it's we just let our clients know that they should be talking to the counselor about the fact that we've approved it and whether that counselor will actually accept a client through the Crime Victim Assistance Program. Is there an up-to-date list of CVAP counselors available to the clients? If I was to provide that list, there would be over 5,000 counselors on it right now, so I do not provide that list. And so for the most part, because it is the claimant's choice of who they see, I don't want to put anybody in a position of saying that you are limited to the people who have currently registered. We don't imply anything with registration for our clients on whether that counselor would be appropriate for them, whether they would actually work in the circumstances for them. That is completely up to the claimant. If the claimant doesn't feel comfortable with that client, we don't want them to feel that they are required to because they're already registered with CVAP. They are free to choose the counselor of their choice, and if the counselor is not registered, then that person can be registered afterwards. The only times that we'll actually provide something to a client as far as who is registered is if they're living in a smaller community where we want to where there's limited options, so we can say that these are the people who are currently registered, but still inform them that they can actually, if they find somebody who is not registered, we can look at them as well. And for people who are living in larger urban centers like Vancouver, there's no way I can give people a full list, because I don't want the implication that we prefer one counselor over the other. As the funding body, it's not appropriate that we're actually telling people that these people are actually, or even giving them a sample list and saying here's 10, because I'm sure the other 300 people that I haven't provided their names to would not appreciate that I have not provided their names. And the next question, if a trial is set but canceled, is the claimant still eligible for this? Then likely yes, because prior to that, then there would be things like preliminary inquiries and everything else going that have occurred prior to that. If the trial date is then canceled, well, then it depends on what you're talking about, whether it's canceled and then rescheduled, or it's canceled because that person has then pled guilty and then then it's over. Once it's over, then the person has 18 months from the time it's over to continue to access these benefits. So as long as there is some legal proceedings that have started, then these benefits are actually accessible to them. I'm getting another question from one of my staff, actually. Yeah, I mean, I guess about just further clarifying the one-year time limit issue. Again, the one-year time limit issue applies to time to submit your application, not in the time to access the benefits. So as long as we've accepted that claim, the person can come back to us 10 years later because now it's parole to access the benefits, or even if it has nothing to do with any kind of legal proceedings and there's been a triggering event where they're now prepared to take counseling for whatever reason, they can still contact us to actually ask to utilize those sessions that were awarded at the time of the decision. So my first question is, for that your client had legal proceedings that ended a year ago, can they still access this benefit? The answer is yes, as that benefit has an 18-month expiry date, and then they still have access to this benefit for 6 months from now. And we can look at the sessions they've had in the year prior, because the benefits are good for 18 months from the conclusion. So we can still look, and administratively we can look at whether any of those sessions that they've had in the past year should have been applied to this benefit. But then that'll be conversations that we're having with the claimant and the counselor to confirm that whatever they've had in the past year, to see if we've already applied it to the regular counseling benefit, to see if we have to make adjustments some way internally. And my question is this just an extension of the counseling benefits? I would say no, it's not. This counseling, again, the intent of this benefit is to support our claimants through the legal proceedings. It's not just, here's a new group of 24 counseling sessions to use for whatever purpose you like. It is really to assist through those legal proceedings, because we recognize that going through court causes additional trauma. So when we are getting counseling for legal proceedings, my staff here will consider the length and type of proceedings and approving the sessions. So if court lasted all of a day and then stopped, then we will be asking the counselor questions about whether that person actually did need 18 counseling sessions in relation to something that was in and out of court. So again, the intent is to assist in the legal proceedings and not just an extension of counseling. Now the question I have, does this include accompanying the client to court? Bernadette, can you expand on that a little bit? Because the counseling is for the claimant, so that's fine, or are you talking about another benefit as far as transportation, or if you can expand a little bit there, I think I can provide a better answer. Well, we're providing assistance for the counselor, so we don't pay for the counselors to go and sit with the clients in court. That's not what a counseling session is for us. So if a counselor is actually going and just sitting in counseling for court, I'm not going to pay for that, because that's not a counseling session. This is a support session, and that's not what counseling is for us. Does the claimant need to attend court to access this benefit? No, they don't. The counseling sessions here are available for this court support counseling, whether or not the person actually goes to court or not. If we're thinking, counseling is certainly, the court process can certainly be traumatizing whether you're actually in court, because even if you know that court is actually going on. or especially for immediate dying members, that they may not be attending when we're talking about where it's fatal files or anything else. So they don't need to be attending court to be able to access these counseling sessions. We know that court proceedings can be traumatic regardless, so they don't actually have to be physically present in court to actually access these benefits. Next question, are there any court preparation resources available to counselors? Not that we provide. We can only provide the counseling the sessions actually with the claimant. We don't require our counselors to, I don't know if you're asking about the counselors. The counselor shouldn't be actually presenting in court. So, but no, we don't provide them any preparation for any preparation counseling sessions at all. And with that, that's the end of my presentation. I am sure there are lots of questions. Hopefully I've been able to answer some of the ones as they've been going on, but I am sure there'll be lots as soon as we open up the phones. So I'm going to wait until there's one more question being typed in. I'll wait until that one, and then we'll open up the phone lines for your questions. Tanya, so your client used all 48. They're being interviewed by the probation officer, accused pre-sentence report. He's pleading guilty. He's pleading guilty. He does not have to attend, but is choosing. Yes, they're eligible for the court process. They're still ongoing. If she's used them all, then I would have Tanya, either you or the client, contact us directly, because we'll likely need a reassessment. If the claim is that old, then probably the decision went out prior to this benefit being available. So she'll need to contact us about it so we can do a reassessment. Will these regulations be applicable on current claimants too? Yes, they are. So for our current claimants who this benefit started at, where their decision was done prior to this benefit being available, then yes, this benefit is available. We're trying to handle that internally when we can. So when we know that somebody has used up all 48 counseling sessions and we know they're still in court, then we can proactively do those decisions for reassessment. But otherwise, we'll need the assistance of the victim services community and the counselors to actually notify people of it. Because again, I probably have about 17,000 files in my file room right now, and that's only going back for about the last 4 years. So there's no way for us to kind of monitor those. So for the most part, like I said, it's very few clients that we have each year that utilize all 48. And so the only clients that it's like the situation that Tanya typed in, is someone who's used all 48 and still needs. Right now, those clients, I would say the majority of our clients use less than 15 sessions, almost all of them, to be honest with you. Hold on, I've got to slip back because I think I'm getting more questions than I can actually go. Let me see. If the decision to award benefits for any type of counseling, is there a difference between registered clinical counselors and CVAP approved? Registered clinical counselor is, that's certainly the accreditation to the BC Association of Clinical Counselors. We have lots of approved counselors who are not RCCs. We have our regulations specify the education and experience qualifications to bill out. So they do not need to be an RCC to be a counselor, but they do need to meet the education and experience qualifications within Schedule 2 of the regulations. If a client was not accepted for victim status but called to court, can we offer the 12 sessions for court counseling? No, if they were not accepted from a claim for us, then there's no way for me to pay for it. So they do need an accepted claim for us to pay for these counseling sessions. Do I provide the counselor to provide a report? I might, but only on request. So if we do see, for the most part, we're going to award the counseling sessions. If there is a reason that we need that progress report, then we'll ask for it. But otherwise, unless we ask for it, we don't need it. My name is Grant McKellar. I am the director of the Crime Victim Assistance Program. So by all means, that's who I am. And as a client, how is he or she supposed to apply for more counseling sessions for previous legal proceedings? Do they have to apply themselves? They can just give us a phone call. There's no new application. Once we've actually received that application and written decision, we do not need another application. We just need something from the claimant saying they need more counseling. That can, frankly, we can be by a phone call for the majority of our claimants. So please don't encourage them to submit another application for the same offense. We've already got that. And with that, Steve, I think we should open up the phones.
Conference is no longer in lecture mode.
To answer for the contact number is the one that you see on your screen, which is our main contact line, which is 604-6603-888. If the client already has an existing claim with us, my admin staff, if they don't know their claim number, my admin staff will direct them to their claims coordinator, who is assigned to their file. Is there any questions?
When did the benefit come into effect?
Came into effect right at the end of December. Someone just spoke, but I couldn't hear what you said at all.
Are there any questions on the phone line?
I do have another question on here about what if a claimant wants to access this benefit in relation to court proceedings that concluded years ago, before the benefit was available. Essentially, they can go back as far as June of 2016, and we can look at whether some of those counseling sessions they took was actually related to court proceedings, because the benefit has that 18-month time limit, so we're looking at 18 months prior to the regulation coming into force. 17. The benefit came into effect December of 2017. Is the court proceedings limited to a certain type of offenses? Well, it's limited to the offenses that we've accepted the claim for. So when we're talking about the legal proceedings that we can cover, it's based on that approved claim. So if there's other legal proceedings that have nothing to do with the application, then we don't do it. So it's particular to the crime that we've accepted in that claim. Are there no other questions?
Could I ask a question? Just, I'm in a smaller community and fairly new to the role, but we don't have a lot of counselors that are registered with you guys.
Yeah.
I did have a counselor who said he may be interested. Does he just contact your program directly to make that happen?
Yeah, by all means, you can just email us at the email at our CVAP@gov.bc.ca email. Essentially, what we'll do is we'll send him information as far as what we need in order to do that registration, and then it's essentially all we're asking for. Especially if he's, for example, an RCC, then we need confirmation that he actually is a member in good standing, because the qualifications for the RCC are similar to our counseling registration. We know that they have a master's degree. We just need confirmation in that case that they've passed a criminal record check and they have appropriate liability insurance.
Okay, perfect. Thank you.
I do have a question. When can a client start counseling sessions? They can start them whenever they like. I mean, we do have clients who certainly they start accessing counseling even prior to us making a decision. That's just a question of risk management that that we're actually going to accept the claim. But once we accept the claim, if there has been counseling that's taken prior to us actually approving it, we can pay for those counseling sessions as well. And when it comes to particularly about the counseling for legal proceedings, then we need to we need to make sure those legal proceedings are ongoing in order for us to attach them to that benefit category. If they haven't started, then they would be part of the regular counseling benefits. Question: our victim services contract states that we cannot refer to our victim services workers as counselors, even though many are based in qualifications education. I don't know. That's part of your contract. I can't answer that. That has nothing to do with the Crime Victim Assistance Program. So that might be a conflict within actually referring to yourselves. I don't know. That would be a question that you should talk to your program manager about. I'm not involved in the contracting processes for victim services.
I have a question.
Yes?
I too am from a small community that have limited counselors in town. Does your program cover telebehavioral health issues or counselors on Skype or some such thing?
Yeah, we can certainly do that. I mean, that's something that we've adapted over the course of time as well. I mean, it was previous, in years gone by, we asked for pre-approval on things like phone counseling. Certainly now that Skype is becoming much more acceptable, and I believe that most all the counseling bodies don't see any kind of concerns with providing counseling over the phone or by Skype, so we can do that as well. That's perfectly fine. One question about clients being granted 24. We normally award counseling in blocks of 24 because if somebody is taking more than 24, then that's usually when we're actually asking for a progress report. So we do send something to the client when they're getting close to 24 that if they need more, that they need to contact us to ask for a reassessment. Does the claimant need to contact CVAP to ensure that the legal proceedings are eligible before they start the court support counseling? The answer to that is yes. Again, because we have likely awarded this benefit without knowing that any court proceedings are occurring, because we might be writing our decision saying that these sessions are available prior to Crown approving charges. So they should be notifying us saying, yes, I want to use it for these benefits. But worst comes to worst, if we get a bill in from the counselor that says court support, then we'll look it up at that point in time. We do want to make sure that people are using the counseling appropriately and they have as many sessions to them as they can. Give me a second, I got to scroll up because I'm getting a couple questions at the same time. If a person is already approved for counseling sessions and now there's a trial, can they apply for legal proceedings counseling? Yes, they can. They don't have to let us know about the trial. They just have to ask. We can actually pull that information up about the trial ourselves. Right? Like I said, we have access to Justin, which is the court system. So if they call us and say that there's a trial underway now, we can look that up. In order to apply for legal proceedings, does the client first need to complete the regular application? You bet. I can't provide any benefits unless somebody applies. It doesn't matter what benefit they're actually looking for. I need an application to the program for benefits. Right? If they're out of time but they're applying now because trial is happening, well, then that's what we would ask people to do even prior to this benefit coming into force. We often had people who are applying saying they're applying out of the time limit because trial's happening now, and it's perhaps the circumstances of trial has affected them more than they thought they needed to, and that's why they need counseling now.
Bram?
Yes?
Is this webinar going to discuss any of the other benefits besides counseling?
It wasn't the intent of the webinar. This webinar was for court support counseling. If it's a specific question, you can by all means you can contact us directly.
Oh, it's pretty deep. It's regarding the other benefits, the whole list of benefits that may be provided to clients on the back of the application sheet.
Yes.
Is there any special circumstances where clients will get those? I find that getting counseling seems to be very good for our clients. It's the other things that we're struggling a bit to access. Is there circumstances where, they have to meet a certain bar to be eligible for some of those benefits on the back?
Well, all of the benefits that we provide have to be specifically related to that they are needed because of the offense of which they're applying for. So, for example, things like dental and medical services and everything else, we only pay for dental as a result of the crime, so we don't pay for dental just because you're a victim of crime. We don't do cleanings and that kind of stuff.
Right.
We pay for dental because your tooth got injured as a result of the assault. Same thing for all of the other benefits, whether it's homemaker services, you need those because of the injuries, or crime scene cleaning, it's because of that offense. So is there a particular benefit you're thinking of?
Well, I was thinking of damage to property and moving, relocating.
Yeah.
Oftentimes they do lose their home through eviction or something like that because of what
there's certainly conditions within the regulations as far as we provide any of our benefits. So for things like damaged property is described in the regulation as only for clothing, eyeglasses, and disability aids are the only personal property that we replace. So anything else that is damaged or destroyed it falls outside of the regulation. And for relocation, we only pay for relocation in the more limited circumstances when someone now has a disability where they have to move because of the disability, and the more likely scenario is when someone needs it because of protective measure. So we only pay for relocation as a result of continuing ongoing health and safety risks, not because of eviction. Not because of eviction, because of non-payment of rent or anything like that. That falls outside of the scope of the program.
Not regarding non-payment. I'm talking
No.
about the incident.
It depends on what you mean by the incident, right? The only time we pay for relocation is for health and safety reasons.
Yeah, where police become involved and arrest the person and someone gets an eviction or... Then
no. The only time we pay for relocation is when it's for health and safety reasons alone. That's the conditions under that's the way the regulation is worded. That's when we provide relocation. It's relocation as a protective measure. That's the only relocation benefit we provide.
Right, and loss of income is that they actually miss because of, let's say, an assault. If the stress is that they miss work, is that something that could be looked at too?
It is looked at. I mean, when we're providing income support, it's people have actually, for the most part, they were working, then they actually were rendered incapable of working, medically incapable of working for a period of time. That it can include psychological. If that period lasts for like any period of time, we can assume psychological trauma if someone missed a couple of days of work. If someone is saying they missed a couple of months of work, then we're going to have to require that we have that medical information to back that up. But we often do income support based on psychological reasons.
Do you do anything other than, let's say, if there's anything that's damaged to their property? Other than, what did you say, glasses?
Glasses, clothing, and disability aids.
Okay. Thank you.
Question?
Yes?
Getting back to the protective measures for relocation, would that have to be verified by police as a necessary option?
Depends on the degree of protective measures someone's looking for. I mean, if we are getting into the point of relocation, then likely yes. When we're providing relocation, the requirements in the regulation is that other safety devices are not going to meet that safety need. So it has to be at a higher threshold. We have to look at whether things like alarm systems and everything else, or alarm systems, cell phones, bars on the windows wouldn't meet the safety need. And if that is the case that relocation is, then likely yes, that we are getting. Even something where we're getting a letter from the police officer assist, or whether we're getting, safety planning, we have to make sure that the move itself is protective in nature. So we're not going to move someone 3 doors down because then it's not protective in nature. So we do need that kind of information when we're paying for the move, where it's to and how it's protected.
But if someone feels that they are not safe, but the police aren't necessarily, convinced or can know exactly how that person is feeling.
We can do it for psychological reasons as well. So we can move someone if psychologically they're not going to recover if they stay there. So we'll need an explanation as far as why they need to move for psychological reasons. Often in those cases, it's because the crime happened in that place, or they don't feel the place is secure enough. But we're going to ask for the information as far as why.
Sure. Great. Thank you.
Grant?
Yes.
One more question, sorry, on this end. Would you guys pay if they can't move, they don't have the expenses to move, for cameras or ABC or any type of security?
Yeah, we do alarm systems all the time.
Yeah.
So that's our first cut, is to make sure that there's can we put in protective devices before we actually say that that relocation is the most viable option. So yes, we get lots of requests for alarm systems. Just give me a second on the phone here. I'm going to go back to some of the questions that I've got online here. Are there any resources for counselors to understand the court proceedings? If the clients are getting more, no, hold on. I can ask people to stop typing in questions as well because it moves everything down. Just want to make sure that I'm getting to all the questions that have come in. And how would they let CVAP know about the trial? Does CVAP require a letter from the client? I get, no, we don't already know. We don't know that. And really, as far as the counselors, I mean, if the person is talking about what's actually going on in court, that's going to be enough for me to say that it's actually court related. Where are we? What type of liability insurance is counselor required? Counselors are required to have $2 million in liability insurance. Current time frame to turn around for the majority of our applications is about 70 days from the time of application till the time that original decision goes out, 70 to 75 days. And of course, that right now we are averaging, I would say, close to 400 applications a month. All of our decisions that when we actually award benefits, we're required by our legislation to provide those decisions in writing. So everything requires third-party information to support the claim and the benefits they're providing, which varies depending on the claimant. It might just be as simple as the police report, but for when someone has injuries, and we're going to require medical information, employer information as well. So we are reliant on third parties actually submitting that information. And then there's a volume issue as far as actually getting out that many decisions. So right now it's about 75 days is probably the closest it is. We do have the ability to expedite when the reason arises. Usually the primary reason why we're expediting is health and safety reasons for the client. Our courts about counseling is limited to victims who are minors at the time of the offense. We're not really providing this benefit, although we could, to minors, mainly because the counseling caps don't apply to minors. So if they need additional counseling support because of court, that would fit within the regular counseling they're providing already, because we can see that as a triggering event. But there's nothing stopping us from awarding that particular chunk. However, the court support counseling is limited for all claimants. So essentially, if a claimant who is a minor wants more counseling because of court, then they've always been able to ask for more counseling for it regardless. Question: can you get liability insurance if you are not a registered counselor? I don't know. That would be a question for the insurance companies, I guess. I have no idea. But as one person said, anyone running a business venture involving counseling would need to have liability insurance. And I certainly know that if you're an RCC, you require professional liability insurance as well. Right? I wouldn't advise anybody who's providing these kind of services not to have liability insurance. And we're not going to register you if you don't have it. All right. Is there any more questions on the phone? Because I think I've got through these ones that are typed in.
Hello.
Hello.
Hi. I'm just going back to the list of benefits on the back.
Yes.
And I was just wondering, in regards to the domestic assault where there's been head injuries or bodily injuries, I'm just curious, is there so if you're in a car accident, you can access physio, chiro, massage, and
yes.
things through crime victim assistance where people get access to those kind of things to help them with those kind of injuries?
Certainly, those have been benefits that have existed all along with us. So we do lots of chiro, physio, occupational therapy, facility costs, you name it.
Is there a certain limit? Because I don't see that.
No, and you won't see it because there is no limit. There is no for things like chiro that we don't have hard caps for those. However, we, like everything else, I mean, we do have to make sure that, one, that it's still required because of the injury from the offense, and that people are actually still benefiting from it. Right? None of our benefits are meant as lifetime benefits unless those services are needed for that person's lifetime. So we will continue to have we do have a consulting physician who will look at those kind of things to determine whether it's still beneficial. But there's no specific cap on those kind of things as far as.
It's not said on their. So I guess that would have to come from a doctor that they would be requiring these things.
By all means. Like whenever someone has physical injury like that, we are asking for medical information. We do go to the hospital to treat them. We do get information from their doctors. So we are looking at the services that are required. As far as what we're providing for healthcare services, we are healthcare practitioners are certainly are certainly governed under BC, and healthcare practitioners are named as far as what we do as well. So we do cover things like chiropractors and physiotherapists. They all are approved healthcare providers. We don't do, but they have to be an actual healthcare provider under the Healthcare Practitioners Act.
And is there a cap on the amount that, like, they have, because with ICBC, like, they'll give you a certain amount, but not, like, the whole amount? And is it for, like, the counseling where there's a cap on the amount that crime victim assistance would cover, or do they cover the whole amount?
It depends on what that person's billing. I mean, if we get a chiropractor bill who's billing $250 an hour, we're not going to pay that.
No, but, I mean, their prices do change. I'm wondering, like...
Yeah, but there's no set limit within those kind of services within the regulation.
Thank you.
Hi, I just wanted to clarify, can they use these benefits after the first appearance and the arraignment hearings, or if something ends in a stay of proceedings, or does there have to be a trial date or a preliminary inquiry date set?
Well, the way the regulation is worded, there needs to be a preliminary inquiry. However, like I said, my staff can determine on whether that's most likely to occur or not. And now, if something actually just goes into an arraignment and the court essentially is very brief, then we can access those benefits. The questions that we would be having as far as how much of the counseling required is because of what actually has happened in court, right? Because these benefits, again, are specific to assisting that person through the trauma that the court process is bringing on. So those are the questions that we will ask.
Okay, thank you.
Oh, is there anyone? Can a person apply if there is no police report? Yes, they can certainly apply if there's no police report. We don't require a police report. What we do require is that we have enough information for our adjudicators to accept that the claim has actually occurred. In the situations where it is things like childhood sexual offense, we'll be trying to collect as much information as far as disclosure that we can to confirm that the offense has occurred. But we don't require a police report in order to accept a claim. We just require enough information for us to determine that the offense has actually occurred. So we'll collect whatever information we can to help support that. But I'll be honest, I mean, having police reports certainly helps us. Is there any other questions?
I have a question.
All right.
Someone reports historical sexual abuse. Do they need to have supporting details of the incident from maybe family members or friends or something, or can they just simply, just give their own report?
Well, they can give their own report. We are a program based on legislation and an evidence-based program, so we will be asked. I mean, it may include an interview with the claimant. The adjudicator has to have enough information to determine that the offense actually occurred. So like I said, if someone has disclosed, or even if they didn't disclose, if there's something that, for a family member, if they said they noticed a change in behavior or something, we'll collect whatever information we can to help support that offense actually occurred.
Thank you.
Are there any other questions? Well, if there are no other questions, I'd like to thank everybody for attending. If you have any other questions, by all means, you can give us a call or send us an email, and we will respond to you as quickly as we can.